Welcome to Steele Law Office. My name is Steele, and our topic today is wills. To make a will, you need to be of a sound mind. This sounds simple, and it is. Being of a sound mind is a relatively low threshold. As long as you're aware of the property that you're bequeathing, and as long as you are aware who your relations and family members are, generally this requirement will be met. Needless to say, you cannot be suffering from a diagnosed mental disorder which will render you incapable of making a will or understanding the effects of such a document. But an occasional forgetfulness might not, or generally will not, render a will invalid. In addition to this, the requirements apply only at the moment that the will is created. You have to understand that if you start suffering from a mental disease or defect later on, after the will was already made, your original mental state will be determinative. Namely, if you were sane and of sound mind when the will was created, the will be valid even in the face of subsequent disability. One of the central questions that clients who come into our office have is, what can be included in a will? As a general proposition, almost any type of property can be included in a valid will. There are certain things that are not advisable to be included in the will. For example, pensions, life insurance, or annuities should not be included in a will for strategic and practical purposes. These pass on automatically to the beneficiaries, and including them in your estate could be done, but it could also delay the payment of the said annuities or life insurance proceeds. Burial instructions are often included in a will, but most often than not, they are referred to in a will and included in a separate piece of paper that gives you the freedom to go freeform and narrate your burial instructions to your heart's content. You can be as detailed as you wish. These burial instructions, most often than not, are considered expressions of your wishes, and depending on how reasonable they are, they may or may not be legally binding. Once again, this is a matter that you should discuss with your attorney before you include it in your estate planning. If you wish to change your will, you have several different options at your disposal. You could make a codicil, which is a formal addition, deletion, or alteration of a term of your will. These should be done by a lawyer, and in no way should you be trying to draft a codicil of your own because you might not be aware of all the legal implications of the changes that you're making. In addition to a codicil, you could also decide to make a new will. Making a new will revokes the old one, and all the terms of the new will be the governing terms of your estate planning. You should be careful not to make a change on the will document itself, because those changes are in most circumstances invalid and will not be honored by the courts. Under some circumstances, the law itself will change or invalidate your will. If you're getting divorced, for example, your ex-spouse is deemed to have predeceased you, unless, of course, the will provides for this specific scenario. Also, if you're getting married, the terms of the will that was made prior to the marriage are voidable at the option of your new spouse. Furthermore, if you destroyed the will, it is considered revoked. One other practical issue when finalizing your estate planning is where to store the will. You may think that as a valuable document, will should be stored in a deposit box. Well, you would be wrong. What happens if you die and no one has immediate access to your valuables that are locked in a deposit box? It is much wiser to keep the will with your passport and other documents that you use more frequently in a safe place in your own home. If you're drafting a will through a lawyer, your solicitor will have a copy of this will, but as a solicitor, I, for example, would not be immediately informed of your death. That is why the courts, for example, Superior Court of Justice in Toronto, offers a storage option for the wills for a nominal fee. That is probably the best recommendation for the storage of the wills. You also need to make and keep a current list of assets, probably in the same drawer as your will, just so that the executor of your estate has the most up-to-date information on your possessions. If you're faced with a certain death, you may decide to draft a deathbed will of your own. Deathbed will does not meet either the legislative or the common law requirements of a will. Nevertheless, these documents can be very important expressions of your wishes and desires as to how your heirs should deal with your property. Deathbed wills are also the most easily challenged in court, and I would not suggest a person to make one unless truly exigent circumstances exist. Most commonly, these deathbed wills are challenged on the grounds that a dying person does not have the mental capacity to make a valid will. And the courts in many jurisdictions, including Ontario, have ruled on this. As with deathbed wills, holographic wills are usually made in situations where something tragic or unexpected happens. Let's imagine for a second that you are lost in the wilderness, or you're in a hostage situation, and you happen to have a pen and a paper handy. If you can create a will that doesn't meet the legislative formalities, but is made in your own handwriting, you could be fine. These wills can be challenged in court, but more often than not, if the desires and the wishes of the testator are clear from the written instructions, the courts will honor holographic wills. While holographic wills do not have a witnessing requirement that is the same as the formal wills, I would suggest that if you're writing a holographic will on your own, you have one or two witnesses by your side to sign and put their names on the document. Oral wills, despite their name, are not technically wills. They are oral expressions of your intent and your wishes. These wills are usually spoken to a witness and are never written down. The most common situation where oral wills come into play is if the member of the armed services in active duty is faced with imminent death. They will dictate their wishes to their comrade in arms. Usually the courts will honor oral wills because of the clear intention that was conveyed, as well as for the purposes of public policy. That said, oral wills can and often are challenged in court. The particulars of each situation will dictate whether the court in the end recognizes an oral will or not.